Courts almost never break the attorney-client privilege with the crime-fraud exception. Unless Donald Trump is involved, which has been happening a lot lately. The former president and 2024 Republican frontrunner is the target of at least 5 criminal investigations: stealing classified documents and lying about it to the FBI, improperly interfering in the Georgia presidential election, tax fraud in New York, plotting an insurrection against the US government, and paying hush money to a former porn star. Now, a man involved in that much drama needs an army of lawyers. But MAGA might as well stand for Make Attorneys Get Attorneys. Because as the law closes in on Donald Trump, his own attorneys are being compelled to testify against him, which basically never happens. But isn't the attorney-client privilege supposed to be absolute? How can the government force Trump's attorneys to turn on him? Well, Trump is learning what all mafia bosses eventually find out, that you can't enlist a lawyer to help you commit your crimes and cover them up.
This witness can't remain nameless forever. I didn't hear that.
But before we get to Trump's troubles, or more specifically his lawyer's troubles, we have to talk about what is the attorney-client privilege. The attorney-client privilege is a legal privilege that keeps communications between an attorney and their client private. The privilege protects communications made orally, in writing, in person, over the telephone, and in letters or emails. The lawyer's obligation to preserve the client's confidence and secrets continues after termination of the lawyer's employment. And that privilege can apply whether you're subpoenaed for documents in a lawsuit. It can also apply if someone tries to compel a lawyer to testify under oath. And the client is the person who is said to hold the privilege. That means that the client can waive attorney-client privilege freely, but a lawyer can't start running their mouth without the client's consent. But that being said, it only applies to communications containing legal counsel. For example, if a business attorney is providing business strategy rather than legal advice, that's not protected. But why does this privilege exist, apart from, lawyers generally writing all of these rules? Well, the reason for the privilege is to encourage clients to be truthful with their lawyers.
I'm going to defend you either way.
It's said that a client is thereby encouraged to communicate fully and frankly with the lawyer, even as to embarrassing or legally damaging subject matter. And the idea is that when a lawyer knows the client's version of the story, the lawyer can test that against the evidence produced by the other side or the government. And in this sense, the privilege doesn't subvert a court's ability to find the truth, it facilitates it. And because the privilege applies to both criminal and civil matters, it's an essential part of the Fifth Amendment privilege against self-incrimination. A person cannot be compelled to offer testimony that might hurt his or her case.
Under the advice of my counsel and for all of the above reasons, I respectfully decline to answer the questions under the rights and privileges afforded to every citizen under the United States Constitution.
If the person's lawyer could tell a court everything that the client said, then there'd be no meaningful Fifth Amendment protection. But there are some limitations to the scope of the attorney-client privilege. For it to apply, there has to be an attorney-client relationship for a specific matter. Courts have rejected the contention that a person can have a lawyer for every issue that might arise in their life. In other words, your consigliere can't remain quiet about everything that they know about you. This principle was illustrated in the 1990s when mob boss John Gotti was indicted for the murder of Paul Castellano. The presiding judge disqualified Gotti's lawyer, Bruce Cutler, and his 2 associates, George Shargell and John Pollock, from representing Gotti. The government had wiretapes from one of Gotti's clubs where Gotti was caught chatting about his lawyer's participation in criminal activity. And during a hearing on the matter, the prosecutor played a tape from Gotti whining about how much money he was paying the 3 lawyers. Gotti says, "Where does it end? Gambino crime family? This is the Shargell, Cutler, and who do you call it crime family." Pro tip, if organized crime doesn't pay enough, become a lawyer. It'll scratch the same itch. But Gotti argued that since Cutler represented him in everything, he could never be a witness against him. A court ruled against the Teflon Don, concluding that the lawyers represent not merely an individual client, but the enterprise with which that individual is associated and receive instructions calculated to further the interests of that enterprise. The 3 lawyers were disqualified because, quote, their participation in the events underlying the obstruction of justice count. And this issue even came up when the Stormy Daniels payments first came to light, before Michael Cohen turned on Trump. Trump simultaneously claimed that he relied on Cohen's advice and that he had no idea what Cohen was doing with the Daniels payments, leading some observers to question whether attorney-client privilege even applied in that case. Cohen was a fixer and lawyer, but if he wasn't acting as a lawyer with the purpose of the Daniels payments, then the privilege wouldn't necessarily apply. And that, of course, brings us to the big limitation on attorney-client privilege, the crime-fraud exception, which states that legal advice that is used in furtherance of illegal or fraudulent activity is not privileged. In 1989, the Supreme Court explained that the purpose of the crime-fraud exception to the attorney-client privilege is to assure that the seal of secrecy between lawyer and client does not extend to communications made for the purpose of getting advice advice for the commission of a fraud or crime. For the crime fraud exception to apply, the client must have been in the process of committing a crime or planning to commit a crime. If the exception applies, a court or grand jury can subpoena the lawyer, and the lawyer must disclose the information. And sometimes the attorney is affirmatively obligated to report that information, like when a witness is in danger or missing, or when there are serious or immediate threats of harm. Now, in the criminal context, the government must generally establish by clear and convincing evidence two things. One, that the client target was committing or intended to commit a crime, and two, that the client target's attorney was used to further that crime or conceal the criminal activity. If the government can prove those two elements, then both the attorney-client and work product privileges are pierced. The exception applies only to the documents and communications themselves that were in furtherance of illegal or fraudulent conduct. The TLDR of the crime fraud exception is that if the client uses attorney's services to commit a crime, communications made in furtherance of that crime aren't protected, and the government can compel the lawyer to produce records and testify against his or her client. Now, while the invocation of the crime fraud exception is extraordinarily rare in practice, this seems to keep happening with Donald Trump's lawyers. You might recall the first recent example was that John Eastman tried to help Trump remain in office even after he lost the election. And when the January 6th committee asked for communications with Trump, Eastman raised the attorney-client privilege because he was his lawyer. But using a preponderance of the evidence standard, a California district court ruled that it was more likely than not that Eastman and Trump had, quote, attempted to obstruct an official proceeding by launching a pressure campaign to convince Vice President Pence to disrupt the joint session on January 6th. Now, in a civil case, the burden of proof for the party seeking disclosure under the crime fraud exception is a preponderance of the evidence, meaning more likely than not, or just more than 50% likely. Now, that exception does not require a completed crime or fraud, but, quote, only that the client has consulted the attorney in an effort to complete one. The exception applies even if the attorney does not participate in the criminal activity, and even if the communication turns out not to help and perhaps even hinder the client's completion of a crime. And an attorney's wrongdoing alone may pierce the privilege, regardless of the client's awareness or innocence. Now, using this standard, the court concluded that the crime fraud exception applied to at least some of the emails sought by the January 6th committee. The court characterized the Eastman plan as a coup. Quote, Dr. Eastman and President Trump launched a campaign to overturn a democratic election, an action unprecedented in American history. Their campaign was not confined to the ivory tower, it was a coup in search of a legal theory. However, once that theory turned into action, the Eastman communications became part of a crime. The action started when Eastman sent Rudy Giuliani a memorandum that included a plan of action for handling the electors on January 6, 2021. The district court concluded that, quote, this may have been the first time members of President Trump's team transformed a legal interpretation of the Electoral Count Act into a day-by-day plan of action. The draft memo pushed a strategy that knowingly violated the Electoral Count Act, and Dr. Eastman's later memos closely track its analysis and proposal. The memo is both intimately related to and clearly advanced the plan to obstruct the joint session of Congress on January 6, 2021. Because the memo likely furthered the crimes of obstruction of an official proceeding and conspiracy to defraud the United States, it is subject to the crime fraud exception, and the court orders it be disclosed. Now, Eastman argued that there was nothing wrong with writing a memo that described a way for Pence to discard electoral votes as long as his legal analysis was made in good faith.
I mean, it's amazing.
Well, but I read your memo and I thought it was solid in all of its legal arguments.
Yeah.
And I was floored that Mike Pence didn't do anything. I mean, why didn't he act on it? Because you gave him the legal reasoning to do that.
I know. No,
The judge concluded that Eastman's actions could have been against the law. Quote, Dr. Eastman argues that the plan was legally justified as it was grounded on a good faith interpretation of the Constitution. But ignorance of the law is no excuse, and believing that the Electoral Count Act was unconstitutional did not give President Trump license to violate it. Disagreeing with the law entitled President Trump to seek a remedy in court, not to disrupt a constitutionally mandated process. The illegality of the plan was obvious. Our nation was founded on the peaceful transition of power epitomized by George Washington laying down his sword to make way for democratic elections. Ignoring this history, President Trump vigorously campaigned for the vice president to single-handedly determine the results of the 2020 election. Now that brings us to the recent bombshell allegations involving Trump's new lawyer, Evan Corcoran, and the Mar-a-Lago documents case. Special counsel Jack Smith is currently presenting evidence about the classified documents case to a grand jury in Washington, D.C. Smith asked the district court to allow him to question Corcoran about a phone call he had with Trump on June 24th, 2022. Prosecutors believe that the phone call discussions were in furtherance of illegal activity, and they asked the presiding judge, Beryl Howell, to pierce the attorney-client privilege. Prosecutors wanted to know what Trump said and whether he gave Corcoran any orders about how to handle the government subpoenas. So how did Corcoran find himself in this predicament? Well, you might remember Trump's quest to stop the government's investigation by appointing a special master who would in theory slow or shut it down. When the parties were battling it out in court, the DOJ filed a response explaining that Trump's lawyers certified in early June that a, quote, diligent search of Mar-a-Lago had only turned up 38 classified documents, all of which were supposedly kept in a secure storage room. Christina Bob signed a document asserting that the search was complete, or probably attesting that she was informed that a diligent search had been completed. But when the FBI did the first search of Trump's club with his consent, Corcoran was at Mar-a-Lago. He, quote, explicitly prohibited government personnel from opening or looking inside any of the boxes that remained in the storage room, giving no opportunity for the government to confirm that no documents with classification markings remained. Corcoran told investigators that he had been advised that all of Trump's remaining records from the White House remained in that storage room. Presumably, Christina Bob was the person who advised him that all the remaining records were in that storage room, but Trump might have told him that as well. But then in August of 2022, when FBI agents served a warrant on Mar-a-Lago, they found more than 100 additional classified documents. The DOJ said that some of these documents were located outside of the storage unit. Now, there are basically two ways that this could have played out. Either Corcoran knew that there were other classified documents inside Mar-a-Lago and he deliberately misled the investigators, or Trump and his minions misled his legal team and the lawyers unwittingly repeated the lie to the investigators. And based on Judge Howell's order, it looks like Trump purposefully misled Corcoran and the other lawyers. And in a sealed filing, Judge Howell concluded that the prosecutors in Smith's office had made a prima facie showing that the former president had committed criminal violations, and that attorney-client privileges invoked by Corcoran and Jennifer Little could therefore be pierced. Such findings are extraordinarily rare, but Judge Howell made a similar finding in Robert Mueller's cases against Rick Gates and Paul Manafort. Judge Howell ruled that Gates and Manafort hired a lawyer and fed her deliberately misleading information to conceal that they were working for a Putin-backed Ukrainian political party. The lawyer then submitted a letter that was full of that misleading information. Judge Howell ruled that the crime-fraud exception applied in that case as well. And here, Judge Howell made a similar ruling for similar reasons. Sources added that Howell had also ordered Corcoran to hand over a number of records tied to what Howell described as Trump's alleged criminal scheme. Those records included handwritten notes, invoices, and apparently transcriptions of personal audio recordings. Yes, it appears that Corcoran has recordings. Now, we don't know if Corcoran recorded his conversations with Trump. It wouldn't be the first time that one of Trump's lawyers recorded a conversation with him, which is not normal, by the way, or if these are just conversations with other lawyers or with Trump's employees. But Judge Howell probably didn't make that ruling based on a guess about what Corcoran might have. It's very likely that Smith actually asked Corcoran what records he had, and Corcoran cooperated by answering truthfully. That doesn't mean that Corcoran disclosed privileged information, contrary to Trump's rights in that case. There's no legal reason why a lawyer has to withhold the fact that certain categories of documents and things, like documents and recordings, actually exist. But at that point, Corcoran probably then properly invoked the attorney-client privilege about the contents of what was in those categories of things. However, here it's likely that the judge ruled that Trump was lying to his lawyers about a criminal scheme, and therefore Corcoran had to cooperate. And you can see the bind that Corcoran is in here. He might have unwittingly participated in his own client's criminal enterprise. And maybe that's why there are recordings. He certainly knew what had happened with his predecessor, Alex Cannon and Michael Cohen. Now, Trump briefly, and I do mean briefly, got a temporary stay of Judge Howell's order. The DC Circuit, the Court of Appeals, ordered Trump's lawyers to file a memorandum of law that day, on Wednesday, March 22nd at midnight. And the DOJ's response was due 6 hours later at 6 o'clock in the morning the following morning. That's a briefing schedule I've literally never seen in my entire life. And by Wednesday afternoon, the DC Circuit had ruled against Trump and his lawyers. But since grand jury proceedings are secret, we can't show you that order because it's not public. So now prosecutors will get to ask Corcoran if he reviewed Christina Bob's affidavit, if he made any attempt to edit it, and whether he knew that there were other documents in an unsecured location. Now, sources say that lawyer Jennifer Little will also have to testify before the grand jury because she was covered by Howell's sealed order. Jack Smith probably wants testimony from Little, even though she never entered an appearance as Trump's lawyer with the documents case. So we can only speculate as to her involvement. On May 3rd and 4th, 2022, Little posted photographs of herself at Mar-a-Lago. We don't know if these photos were actually taken on the dates that they were posted. However, those days are particularly significant. On May 1st, 2022, Corcoran asked NARA for more time to gather documents, and on May 3rd and 4th, Little was apparently at the scene. Then on May 5th, Lena Haba, another one of Trump's lawyers, searched Mar-a-Lago for documents responsive to a subpoena from the New York Attorney General. Now, perhaps Perhaps Little was on hand to search the private club for responsive materials. She might have been there to assist Corcoran, Haba, or both. We simply don't know at this time. But as you can see, Smith is seeking testimony from everyone who was involved in or aware of the movement of boxes around Mar-a-Lago and the location of the documents. Now, ABC News reported that Fonnie Willis, the DA in Fulton County, Georgia, wants to hear from Christina Bob, even though she doesn't represent Trump in the Georgia case. Bob's criminal lawyer said she will refuse to testify in that particular case. And then there's Lena Haba. She's already testified to the grand jury in February. She represents Trump in the New York Attorney General's case. And when she searched Trump's residence and private office on or about May 5th, she said that she found no responsive documents. And one of the thorny issues is that if she did see classified documents, she didn't have the clearance to actually examine them. And when she did her search, it looks like most of the classified documents were still in the storage closet where they were moved before Corcoran did his search. And the storage closet isn't in the residence or Trump's office. And the emerging theme here is that these lawyers might be witnesses to potential crimes. And their testimony would be useful in proving that Trump maybe purposefully instructed lawyers to search areas where no classified documents would be found, or instructed them to tell investigators not to look in certain places, or told other people to remove boxes to hide them from investigators or lawyers. It's a mess. Now, losing attorney-client privilege for crime fraud is just the latest legally unprecedented move involving Trump. There's so much stuff that I can't release everything on YouTube. But thanks to the power of today's sponsor, Nebula, you can watch all of my videos ad-free and early, because my videos always go up on Nebula first. Plus, there's tons of exclusive content. For example, when you sign up for Nebula directly, you can get access to Nebula classes, which includes my entire course, How to Sue Like a Lawyer. That used to be hundreds of dollars a year, and now it's free and included with your direct Nebula subscription. You also get access to Nebula-only videos, like the deep dive that we took on Trump's criminal mental state for the various crimes that he's accused of, and the crimes that Steve Bannon was pardoned for. And that's just a few of the tons of exclusive videos that are only available on Nebula. And I make exclusive content on Nebula all the time. Because what's truly special about Nebula is that it is a creator-owned platform built by me and other YouTubers and podcasters. And because it's a subscription service, we get to work on larger, higher budget productions than we ever could on YouTube. So if you sign up using my link that's on screen right now, you get an annual subscription for just $30, which is 40% off the regular price. You'll get all my videos early and get access to exclusives and support the ambitious projects that my friends and I are working on our own streaming site. So sign up now and get 40% off by clicking on the link below and get Nebula for only $30 a year. And then after that, click on this box over here for more LegalEagle, or I'll see you in court.